Hi everyone, welcome to another episode of SCL Talks by SCL Turkey. In this episode, we will focus on key legal and contractual issues faced with by the Turkish contractors on international projects, which impact on the ability to complete them successfully. Today, our guest is Vincent Rowan. Actually, we are guests of Vincent, and thank you very much for accepting us your facilities today.
Our pleasure. Welcome to King & Spalding.
Thank you, Vincent. Vincent is a partner in King & Spalding law firm in London office, and his practice focuses on the management and resolution of complex construction and engineering disputes. Vincent has represented clients, both owners and contractors, on disputes related to some of the world's most iconic infrastructure and energy projects built during his 30 years of experience. Vincent is recognized as a leading lawyer in the field of construction and engineering law by all major legal directories. Vincent, my first question would be a more generic one. Based on the experience and lessons learned, are there strategies which Turkish contractors can use to overcome some of the key challenges they face?
Yes, of course. I mean, we all recognize that the industry is incredibly tough and incredibly competitive, but that causes major issues that we see as lawyers, and I guess at HK and consultants, you face the same or similar challenges that the contractors come to you with. But that environment is not going to change. If anything, it's going to get tougher. I think with governments having huge oversight, with regulatory oversight, the influence of project finance, the influence of shareholders, I think one of the things that we have to reflect on is that contracts are going to get tougher, and therefore the lessons that we can learn from when we faced challenges in the past can be incredibly powerful and useful to develop a strategy to meet those new challenges looking ahead. I think at the heart of that, there is no easy answer. It is really tough, and we know and recognize it's tough. But I think at the heart of my view, based on experience when looking back on problem projects, is that a real focus and an awareness and a recognition of the need to manage a contract, not just from the project and technical point of view, but also from the contract point of view is really important. I sort of capture this by saying contract management as well as project management. Yeah. And I think it has to be done throughout, consistently through every phase of the project. Because I think if you fall down on the execution, having negotiated a good set of conditions of the contract, then you waste that investment. So it's really important to link that strategy together, and we can see based on experience that that is where contractors are most successful.
Yeah, obviously. Yes, there are different challenges at each stage of construction projects, and you mentioned about sustained strategy from tender through completion stages. Starting from the tender and contract negotiation stage, is it realistic for Turkish contractors this is well for any contractor actually, to seek significant changes to contract conditions proposed by the employers? And if not, how can contractors otherwise improve their position before signing a contract?
Well, it's a really good point, and traditionally when contractors come to us, they say it was a take it or leave it situation. Yeah. We had no choice. The employer insisted on these conditions. What realistically could we do? And that's understandable, but there are still, I think, strategies that contractors can use that are realistic. You're not going to make wholesale changes to employers' required terms and conditions. That is unrealistic. However, I think you also have to question, based on experience, is it sustainable? Is it perhaps even irresponsible to accept all of the onerous conditions that an employer seeks to impose on a contractor? Especially when you have this cocktail of risks. So I often say, if you're working in a very familiar market with an employer you know well, using a technology you're very familiar with subcontractors and vendors you have long-standing working relationships with, then of course your attitude towards change can be much lower. You can accept a greater level of risk because of the assurances that that environment offers you. However, we see real problem projects where people have accepted crazy risks on design, on site conditions, removal of those dispute processes that are aimed to give you early access to third-party oversight. Yeah. And when that happens, you see contractors really fall down. You know, we had a case of a contractor in Asia who worked in a market for 15 years and made, you know, decent profits over that time. But we were involved in a project where he'd lost so much money on a project which almost was doomed from the start. It wiped out all of the profits in that market, and in effect led the contractor to even question its attitude towards working internationally. It sort of coloured their judgment from that point forward. So there are telltale signs on a project where you really have to increase your awareness. And it might be that you can just nudge contract conditions. Maybe it's a possibility to say, if you adopt this alternative, we can offer a schedule or a price. So it's yes, but please allow us to do this. You know, we see things like an employer saying you must use this vendor and subcontractor. You must accept full risk for design at a stage when that vendor might not be a good technical solution or have the commercial strength to actually support that project, or a design that's changed very late on in the contract, the tender stage. What chances do you really have of challenging, testing that change and what its implications are late on in a tender? It's very difficult for a contractor. So when you combine these things together, it can mean you accept a risk. So the awareness of those telltale signs and maybe greater levels of due diligence by a contractor are really valuable. I mean, when we say to a contractor, you know, what due diligence? They say, well, what do you mean by due diligence? We're not buying the company, we're just going to participate in the project. But an understanding of an employer, their track record, their attitude towards these projects, the funding they have, their strengths, is really important. Sure. And that's where I think a strategy of awareness, of nudging a contract and being aware of those telltale signs that could lay the seeds of a problem project are really important.
Definitely. This is about the tendering in early stages. Coming to the project execution stages, and based on your experience with the Turkish contractors, have you seen a reluctance by Turkish contractors to actively manage and use their contracts, issue notices, and make claims? And if so, what have been the reasons and consequences? Actually, my question speaks itself, yeah, exactly. But let me hear your experience.
No, of course. And the question you pose is a very good one, because our experience is probably shared with your own. That culturally and from a business perspective, a lot of Turkish, and it's not just Turkish contractors, by the way, a lot of the Asian contractors share this commitment to a project and a real hesitancy towards using the contract from, you know, against an employer. If they want to be aggressive in the way they manage the contract, they feel that would damage their reputation, damage the relationship, and undermine their ability to continue working in that marketplace or for that owner. So it's a common issue, and we see this regularly. The problem is, being absolutely frank with you though, is that Turkish and any contractor does this at their peril. Because increasingly we see Turkish contractors and other contractors relying on the promises of an employer, relying on the employer dissuading that approach to the management of the contract. But that can't be reconciled with the terms and conditions of the contracts that employers are insisting upon or funders are insisting on. They include very great transfers of risk on the one hand, and also very restrictive rights to seek additional time or money if circumstances or changes occur. So, to my mind, managing a contract and overcoming this hesitancy is not optional, it is absolutely essential. You know, we're working with Turkish contractors now that when you speak to them in a private room and privately, they acknowledge that they relied on the commitments made by the employer. They failed, you know, maybe their senior staff said, no, please don't do that, please don't issue a notice, please don't refer to the contract, it'll be all right, we will get a deal done, I have confidence we do this. Yeah. But when a big issue arises and a big claim needs to be made, that's when the contractor realises the error of that approach, unless they're absolutely sure they know that owner. And excuse me, one of the things we see very time and time again is this attitude being perhaps more understandable at the start of a project, sort of honeymoon period. Yeah. You sign the contract, there's a huge degree of enthusiasm, the budgets look good, the schedule looks good, and people's awareness of the issues developing is probably not as great as it ought to be.
Yeah.
And yet the seeds of dispute can be sown really early in that design phase, that early phase when people aren't paying as much attention to this. But if you have those early issues on access or design, they feed through and cascade through the project, especially when you have a schedule which very often is very ambitious. There's no room for error. So once you start on the wrong foot, it's very difficult to recover it. And we see time and time again. So Turkish contractors need to achieve that really difficult balance. On the one hand, the real commitment to the project that they're so famous for and why they're so successful, but ally it to a real requirement to manage the contract, not in an aggressive way, but in a nice, balanced way.
Yeah.
Because employers trust me, because we work are hiring lawyers, hiring consultants, sitting behind their conditions and their legal rights. And when push comes to shove, when a real claim or issue arises, they will rely on those. If you haven't issued the notices, they will say, well, I'm sorry, if you told us earlier, we could have done something about it, we would have recognised it, but now it's too late. I have shareholders, I have government committees to respond to, so it's very difficult.
Yeah, they have to manage the project, they have to manage the employers' expectations, but in the meantime, they have to manage their own interest, and I understand it's through managing their contract successfully.
Yes, you can't. The project and the contract go hand in hand, and there's a real focus on project and delivering a great project, but less focus on protecting the interests under the contract, and that comes at our experiences looking at, because we only get involved in the problem projects, so perhaps we see it through the wrong lens, but suffice it to say, some of the biggest issues we face are you don't need that at the start of a claim. You don't want to have to overcome those issues before you even get to proving your claim.
My last question is about the later stages of the projects, project closeout stage and the claims. Most of the time claims are pushed to the end of the project.
Cool.
Are you seeing any trends or strategies that Turkish contractors can use to better address the issue of negotiating or securing their claims towards the end of or after a project has been completed?
Yeah, I mean, I think it touches on what we've been discussing. Hopefully at this stage, there'll have been a greater awareness around the acceptance of risk and hopefully better contract management. And that really does lay in the foundations for a much better position towards the end of a project and the attempt to resolve any claims or disputes that arise. And the trends we're seeing are pretty obvious and known to many. Owners and employers are saying, prove it, prove it, prove it. And knowing that that's the likely reaction, and quite frankly, from an employer's perspective, it is an understandable reaction because they have to answer to people that are saying, why are we paying this additionally? Why is our project delayed? Why should we not be entitled to our liquidated damages? I mean, why are we paying these people more money? You know, they promised a fixed price, and now they're saying. So if you one of the things to do is to reflect on the pressures and attitude of the employer. Think from their standpoint before you present your own standpoint, because I think that will educate you and inform you as to how best to influence a positive decision. And I think the way to really do that, there's a couple of things that I would always recommend, and sometimes this is not welcome to a contractor, is to invest early. And that comes back, you must, going into these projects, recognise the need to have really good resources, especially on planning, because it's such a specialised task, and you really do need good people. The other thing is to take a step back. When you know you face a real issue, use people that are perhaps less connected to the project, a fresh pair of eyes, a more objective sense of where you are and what you need to do to establish a claim. You know, it might be an outside consultant, it might be senior management that aren't involved in the project, it might be a law firm who can give you that guidance on your fundamental rights, which you then can use to help craft your position in a really good way. I mean, it's like a building. You lay good foundations, you get good results. And so my recommendation is to front load this effort, take a more objective view, accept the pros and cons of your position, because then you're much better able to present a compelling argument to an owner. It might influence a negotiated settlement, who knows?
Yeah.
But it might gain you an advantage in, say, a third party, like a DAB. You present, you influence the DAB with a really strong, well-evidenced, well-documented position, which then you can use at a later stage. So when we're drafting or advising, we always think in two levels. Think in the immediate term of what you can achieve now, but also think in the longer term of how good a consistent, systematic evidence and story will be when, you know, God willing, you don't have to face it. But if you do get into an arbitration and you have to prove, it's so much better that you've had that systematic, consistent story, and you avoid the risk and, more importantly, the cost of trying to recreate history. It's not something you've made up as a contractor after the fact. This is a continuation of what you always said and the position you took during the execution or towards the end of a project. And that is incredibly powerful to convince a tribunal or a DAB member. You know, you're telling the real story. You're projecting a real understanding of why the claim situation arose and why there is a justification under the contract for it to be recognised either in time or money. So it's really making that commitment and recognising the immediate and longer term potential of that investment.
Yeah. Vincent, thank you so much. I'm grateful to you and King & Spalding for your contributions, and this discussion was truly inspiring for me, and I'm sure people will appreciate that. And on behalf of SCL Turkey, I'm really grateful again and looking forward for your contribution and involvement in our future events.
Thank you very much for the opportunity. We're always willing to share and support the SCL and our insights and expertise as much as we possibly can.
Thank you.
Thank you.